many of them as we can as we wrap up. So first of the year, I always like to do back to basics. And what we'll cover, we'll talk about sources of authority, which is primarily the statutes that govern you, what your governing documents are. We'll talk about, actually, Bruce will talk mostly about fiduciary duties and the business judgment rule. Spend a little time on meetings. And we'll talk about insurance and risk issues. So we're going to cover a lot of material relatively quick. But here we go. Now, a couple of caveats. Some of you, a large portion of you, live and are board members in Washington State. The rest of you are in Oregon. Most of what we're talking about tonight is applicable regardless of where you are and what type of community you are. But keep in mind, you know, like in my meetings course that I do, I talk about quorum all the time, and I frequently use 20% because that's the statutory default. But I know that some of your bylaws say 10%. I know some of them say 30%. So I get that oftentimes your governing documents are going to trump what the statute says. Where that's significant, we'll stop and point that out, but just keep that in mind. Also, occasionally, if it's significant, we'll point out distinctions between Oregon and Washington law. But like I said, most of what we're talking about tonight applies equally. Now, when I talk about sources of authority, and here's where things get confusing, no matter what jurisdiction you're in, depending on the type of community, statutes are going to apply differently. And there's even more exceptions. I just saw Dennis somewhere. Dennis, Eric, hi, Dennis, how are you? Dennis is on the board of a timeshare, which I don't even have on here because they're pretty unique and they're complicated in some ways. And I also understand there's at least one co-op in Oregon and some in Seattle. Those are rare, so we don't spend much time on those types of communities. But again, tonight we're talking mostly about board members, and so this applies equally. But keep in mind the statutes that govern you, depending on when you were created, the type of community, statutes are going to be different. Now, when I say governing documents, this is what I mean. Declaration, CC&Rs. Now, keep in mind, and I don't know why, but in condominium projects, often folks call the CC&Rs the declaration. In non-condos, for whatever reason, we call it CC&Rs. Same thing. The full title of that document is almost always Declaration of Covenants, Conditions, and Restrictions. And I always characterize that document as sort of the constitution of the community. It lays out the ownership interests. It lays out where the lots are, where the units are. It lays out the authority to levy assessments. Joanne, I thought you had a hand up, maybe not. And then you have the plat, which is the graphical depiction. In non-condos, it's an aerial view and it shows the lots and common property. In condos, it'll have that as well, but it will also show the elevations or the cross sections and the bylaws. Now, here's a question, and if anyone gets this right, Bruce, out of his own bank account, will give you $1,000 cash. Just kidding. Which of these documents on this list are generally recorded in the county recorder's office so that when someone buys in, they get copies from the title company?
The declaration.
Yeah, that's one, always recorded.
Bylaws.
Bylaws. Now, keep in mind, some older communities that predate the bylaw recording requirement may not have their bylaws recorded. That's pretty rare, but yes, the bylaws.
Articles of incorporation.
Yeah, kind of. Those get filed with the Secretary of State. So in Washington and Olympia and Oregon and in Salem. And then the plat is always recorded as well. But here's the other one, at the bottom of the list, rules, regulations, and resolutions. Those are generally not recorded. And in a little bit, we're going to talk about communications and websites and how important it is to make sure that these documents that aren't recorded are readily available. And then when people do move in, they get copies of it. Now, also, this list is in a hierarchy. So actually, we're going to do our first poll. I love these polls. I only had time to do one, but I'm going to launch it now. Did everyone see that? Did it pop up on your screen? So here's the hypothetical. In your CC&Rs, it says that quorum is 20%, but your bylaws say 30%. Here we go. Isn't this fun? This is so fun, real time.
Let's say the bylaws.
Oh, we're almost at 50-50. Bruce, in about 10 seconds, I'll stop it and then you tell us the answer.
I don't know the answer.
I don't either. I was hoping you, no, I'm just kidding. It's interesting, bylaws, interesting. Well, I'm going to stop it. The answer is CC&Rs or your declaration. Now, it doesn't happen very often where there is a conflict, but Bruce and I have seen it many times over the years. And when it does happen, whatever your declaration says controls. So when I talk about the scope of your authority, you find that in your governing documents, the statutes. Now, one slide I don't have in here, which I meant to put in here, is there's a few federal laws that apply to homeowners associations. One is the FCC OTARD rule, Over the Air Reception Device Act. And what that says is it says, well, regardless of what your CC&Rs say, and a lot of older CC&Rs have a blanket prohibition on satellite dishes. Well, this federal law trumps that and says, in most communities, you cannot prohibit a homeowner from installing a consumer-sized satellite dish on their property wherever it's necessary to get service. Or we have the Federal Flag Act. Some of your CC&Rs say no owner may install a flagpole or display a flag. Well, the Federal Flag Act says you cannot prohibit an owner from displaying the American flag. Just so you know, Bruce was very upset that federal law did not include Pittsburgh Steelers flags. One thing about Zoom, I can't tell if my jokes are funny or not. But I saw a few smiles, so okay, I'll keep her going. Emma, is there anything in the chat box that's urgent?
No, I'm gonna try to help Jennifer here better, but otherwise.
Okay. Oh, as far as slides go, yes, I'll post these on our website tonight, or actually realistically tomorrow morning.
Oh, okay, never mind.
Now, in terms of what your duties and obligations and your powers are, there's a lot of obligations, and some of them depend on the type of community. Condominium boards, you have a lot more obligation and maintenance responsibilities than, say, a single family subdivision that might just have a perimeter fence. Budgets is the big one, creation of rules, hiring of third parties, entering into contracts. You can own property. And then, of course, the big one, collecting assessments. Now, Bruce, I'm going to hand this over to you for a moment about whether there's an obligation, an affirmative obligation to enforce CC&Rs.
Well, it's a very loaded question. Typically, the CC&Rs will say something along the lines of the board of directors may enforce the covenants and give them certain options to enforce. And courts have kind of construed may as permissive, and so there's discretionary authority rather than an affirmative obligation. But there's other case law in Oregon, at least, and I'm not sure about Washington, but at least in Oregon, saying that whenever there's discretion conferred to a party under a contract, when the CC&Rs are a contract, then that discretion has to be affected or basically conducted in a manner that effectuates the reasonable expectations of the parties. And so I think that there's an argument that if the board is simply just refusing to enforce any of the CC&Rs, or just picking and choosing in an arbitrary way, then there's an argument that that's a breach of the obligation of good faith and fair dealing, even though there's generally discretion conferred to the board to enforce.
I'm answering, Catherine posted up years ago. I kind of for fun self-published on Amazon community association guidebook, and 6 months later I got a royalty check. I had sold like 12 copies. I think Catherine probably bought 10 of them, but we are working on the updated version. We're going to have one for Oregon and one for Washington, but we'll post an update, I'm hoping this spring. All right, I'm going to cover, this is a pet topic of mine, and that is the distinction between directors and officers. Now, one thing that's unique to community associations, HOAs, condos, is that almost always the directors and the officers are the same individuals. And it matters because, for example, at a director's meeting, a board meeting, when it comes time to vote, let's say you're the secretary. When you're voting in your capacity as a board member, not in your capacity as a secretary. So one way to look at it is owners elect directors, directors elect officers. And what that means is that to remove a director requires a vote of owners. To remove an officer requires a vote of the directors. It looks like my camera just froze. Let me switch. All right. And so when we talk about fiduciary duties, generally speaking, we're talking about in your capacity as a director. Now, the reason this gets confusing is in the corporate world, like IBM, they might have a board of directors of 9 individuals, and then a CEO and all of these other officer positions and totally different individuals. So when you're looking at your bylaws and what governs directors versus officers, keep in mind that distinction, okay? All right, with that, I'm going to turn it back over to Bruce. Now, Bruce and I think it was 2 years ago, went to a law seminar in Palm Springs for lawyers who specialize in condos and HOAs. And we went to this presentation, and the presenter was from somewhere on the East Coast, but he started out and said, "Hey, folks, this presentation is about the F word." And everyone gasped. And he said, "I'm talking about fiduciary duties." Bruce, I'm going to let you take this over and talk.
That's a tease. You got to say a little bit. What is a fiduciary duty?
Well, that's what I'm turning it over to you for that.
So fiduciary duties are, generally speaking, duties that mean that one party has a duty of loyalty towards another party. That you have to act in the best interest of someone else rather than yourself. So a lawyer has a fiduciary duty to their client. There are a number of professional relationships that have fiduciary duties towards their clients. An association has, I guess, sort of quasi fiduciary duties. Certainly, the association manages the money for the owners and manages the common property. But the standard of care for directors in homeowner associations and condos is set under nonprofit statutes in both nonprofit corporation statutes in both Oregon and Washington. So the standard of care is basically to act in good faith with the care an ordinarily prudent person in a like position would exercise, and in a manner that the director or officer reasonably believes to be in the best interest of the corporation. And it's that last one, using your authority in a manner that you reasonably believe to be in the best interest of the corporation is I think the duty that would be considered a fiduciary duty. I usually just like to think of the duties of directors as statutory duties, because it's really that particular statute, and it's the same both in Washington and Oregon, that sets out what your obligations to the community are.
And Bruce, one of the things I recall from that presentation was a case involving a board of directors that frequently in their meeting minutes would make comments like this: vote to approve resurfacing of tennis court because it's our fiduciary duty. And they would do that over and over. And ultimately the court took the position that these aren't fiduciary duties, but you made them fiduciary duties. And now we're going to hold you to this higher standard. So don't go throwing around that you're doing everything because of a fiduciary duty. Anyway, now, Bruce, I'm going to put you on the spot one more time. And not only will you address the business judgment rule, but also whether or not do any of you receive compensation? Most of you don't. You
No.
should, because this is a thankless job. But what's called qualified immunity. Bruce, I'll give it back to you for a couple of minutes here.
Well, business judgment rule and qualified immunity are really separate ideas. business judgment rule is essentially a rule that governs courts, which is to what extent is a court going to wade into the management of a business, or is it going to defer to the judgment of the directors? And generally speaking, a court is going to defer. The court is not going to put itself into the position of the directors if an owner, say, challenges an act or any act of the board and said that it was a breach of their duty. As long as the directors are well informed and are relying on expert advice and are in good faith in meeting these standards of care that I talked about a minute ago, then courts are generally not going to reverse or tell a board that they have to do things differently. So here's
Well
the
said.
slide here. So because they're given this wide latitude, the law will not hold directors liable for honest errors or mistakes of judgment. So bottom line is, bad sort of mismanagement, as long as it's honest and in good faith, is not a breach of your duty. Unless it's completely unreasonable and somebody in an ordinarily prudent person in a similar situation would never have done that. And then it does tie in a little bit to qualified immunity, because under the nonprofit corporation statutes in both Oregon and Washington, it says that directors are only liable for gross negligence or willful misconduct. And so there's an immunity built into the statutes for negligent actions. So some actions that would even be, say, a breach of your standard of care because an ordinarily prudent person wouldn't have done that. There may be immunity for that nonetheless, because it might not rise to the level of gross negligence.
Good. Now I'm going to switch gears for a minute to talk about one of my favorite topics, which is meetings. But first, hi, Joni James. I see you now. Joni, real quick. I've been a little sad since December, because before the pandemic, each holiday season, you would bring several plates of baked goods to the office. And all December, I was thinking, well, the pandemic's over. Surely Joni's going to be swinging by, and you didn't. And so I hope there's a good reason. You're muted. I can read your lips though. And I think you're saying, I'm sorry, and you'll bring some next week. She's putting her glasses on. With that said, Joni, will come back to you. Meetings. In most communities, there's only a couple of types of meetings: annual meetings, board meetings, but occasionally you have a special meeting of the owners. And the number one reason for a special meeting of the owners is usually to recall or remove a board member. And those are always fun meetings. And then occasionally committee meetings. Now, the type of meeting matters, because that's going to dictate the notice. For annual owner meetings, often it's notice no less than 10 days, no more than 50 days. For board meetings, sometimes it's 3 days, depending on your bylaws. And also depending on the meeting, what the type dictates who gets to participate and vote, which I'll talk about in a minute. But one thing I want to touch on for a second is this concept of a quorum. Now, those of you in Oregon, by statute, all meetings are to be ran in accordance with Robert's Rules of Order. The newest edition just came out a few months ago, and you should buy it. I love Robert's Rules. It is the most popular form of parliamentary procedure in the United States. It's not the easiest. In Canada, most nonprofits and even corporations use what's called Sturgis rules of procedure, which is actually much more easy to understand and follow. But in the United States, Robert's Rules is usually the go-to. Fun fact, Colonel Robert, after the Civil War, you know where he ended up? Portland, Oregon. And he was a member of a Methodist church. And the reason he created Robert's Rules is he would go to these meetings of committee members of his church, and he would get really frustrated because nothing was ever accomplished or executed. There was a lot of chit chat, a lot of socializing, which is wonderful. But he was mad because things just weren't getting done. And so he started to write down what he remembered of parliamentary procedure of when he was in England, and that's the origin of Robert's Rules of Order. And Robert's Rules is designed to keep control of large groups. Now, in board meetings, I go to a lot of board meetings, and sometimes they're in people's living rooms. And do you need to follow Robert's Rules strictly in that setting? Probably not. In fact, if you don't know this, Robert's Rules has a special section for boards that are small, 12 or less. And under those rules, for example, you don't have to have a second. You can have discussion at any time, so they're much more laxed. But quorum is this concept. It's the minimum number of individuals in person or proxy necessary to conduct the meeting. So hypothetically, at an annual owners meeting, if your quorum requirement is 20% and the call to order happens at 11 a.m. and you only have 15% represented in person or by proxy, you cannot continue the meeting. You can hang out and have a social hour, but you can't conduct business. Same is true with board meetings. If your quorum is a majority, 5-person board, and you've only got 2 directors, well, here's a question for you. Can directors give proxies to other directors to vote on their behalf at board meetings?
Yeah.
Who said yes?
Me.
No. Paul. Is that Paul?
Yeah.
Hi, Paul. How are you? Paul's from New Jersey, so I'll translate. That was another joke. I'm not sure if it was funny or not. So that's quorum, okay? Now, your quorum is going to be dictated by generally your bylaws, and you're going to have a different.
You didn't answer the question.
What was? Oh, what?
You asked if a board member could.
Oh, no. It's codified in statute in Oregon, Washington. There's case law, but no. Part of your duties, owners elected you as a director. They trust your judgment. And so by giving a proxy, you are abrogating your duties. You cannot give proxies to other folks for board meetings.
I stand corrected. That's good to know.
Yeah. Well, Paul, that's the first time you've ever been wrong since I've known you.
Thank you.
You're welcome. Now, here's another concept also discussed in Robert's Rule, and that is
I'm sorry, can you do
Yes.
a proxy as an owner though?
Absolutely. For annual,
Okay, great.
and keep in mind, and that's why I say, recognize the type of meeting. At an annual meeting, you're attending in your capacity as an owner. You might also be a director, but you get to vote. You get to do everything else that owners get to do. Now, the assembly is the individuals who are entitled to speak and to vote. So in a board meeting, the assembly is the board. Owners technically don't have the right to participate or vote. Now, they do have the right to attend and to observe your deliberation and your discussion and your votes. Now, in an annual meeting, the assembly is all owners. That means any owner can make motions, any owner can vote. And so always remember who the assembly is. Now let's talk about the open meetings requirement. And board members hate this topic. Because the first thing I usually say is, well, if you're making decisions and doing board business that should be done in a board meeting via email, you're probably violating your open meetings requirement. The open meetings requirement, very similar to municipalities, school boards, utility boards. You got to notify the owners when the meeting is and the location, and you have to allow them to observe. Now, I think it's best practice. There's some managers here. Where's Kevin Dorowski? Is he still here? Kevin, if you're there, unmute. How about Heather? Is Heather still here?
What can I help you with, Kevin?
Hi, Kevin. Now, I understand you're recently retired, which is interesting since you're not even in your 40s. But in most of the communities you manage, did you usually have an open forum for the owners to air questions or grievances?
Absolutely.
And yeah, one thing, if you don't know Bruce's background, before he was a lawyer, he was also a manager and actually worked with Dorowski. But is it fair to say best practice is to absolutely allow some form of open forum for the owners to speak at board meetings?
I think it's a really good idea just because it gives those owners an opportunity to vent or to share what their concerns or feelings are. And that's sometimes good information for the board to hear.
Yeah,
Usually do it in a very controlled sort of way. 3
gotcha.
minutes per. What's you find at a school board meeting as well, where
That makes sense.
they have
Yeah,
time?
I think that's advisable, but keep in mind, a lot of owners, in their minds, the open meeting requirement means they get to interrupt the board as in the middle of a discussion. They don't have that right. Only the chairperson of the board can recognize folks as speakers. Now, the exception to the open meetings requirement is what is commonly referred to as an executive session. Now, keep in mind, there should never ever be voting in executive session. Executive session is strictly for the purpose of the discussion of sensitive topics, generally consulting with legal counsel about litigation or legal issues, discussion of delinquent assessments, negotiation of third-party contracts, and then if you have employees or staff, discussion of personnel matters. And so procedurally, the way it generally works is some point during the open meeting, a board member makes a motion to go into executive session, discuss one of these topics. The board either asks all of the owners to excuse themselves, and on Zoom, this is pretty easy nowadays. You can do breakout rooms if you want. You have the discussion. If a vote needs to take place after that, then the vote takes place in the open meeting, and it should be recorded in the meeting minutes. Meeting minutes are also another pet topic of mine. And sometimes I tell board members, remember, they're called meeting minutes, not meeting hours. That's supposed to be kind of funny. Meaning, I don't see the value in most situations of a set of meeting minutes that is a transcription of everything that everyone said and did during the meeting. Robert's rule says meeting minutes should say this: the motion, who made it, and whether it passed. And one of the issues that I have seen that comes up is if you try to record a summary of the discussion and the deliberation, usually it's not accurate. Usually there's a lot of time spent at the next meeting minutes editing the minutes because one director says, no, I didn't actually say that, or that's not what I meant. But here's the other thing. I also recognize that some communities, a lot of the owners don't live there, they live off-site, and the only way they get information is through these meeting minutes. I get that. And so maybe in some circumstances, it makes sense to be a little more detailed. One thing to never, ever put in your meeting minutes is advice from your lawyer, because that has the effect of waiving attorney-client privilege. Bruce, any other takeaways or topics on open meetings?
You want to talk about the requirements to go into executive session?
Actually, I'll let you, since I've been talking. I'm going to have a drink of water.
Well, at least in Oregon, I guess I haven't looked at Washington statutes on this, but in Oregon anyway, the presiding officer is meant to state the purpose in as much specificity as is practically possible of why the directors are going to adjourn into executive session. So sometimes that's difficult, particularly when you're going to consult with legal counsel. And so I think generally the presiding officer can just state one of these 4 purposes that are on the screen. So you can say, well, we're going to move into executive session to consult with legal counsel, or we're going to move into executive session to discuss delinquent assessments. But that statement is meant to be made before you go into the private session, and then also is intended to be noted in the minutes. And in fact, the statute also requires a presiding officer to say when the directors expect that the content of that executive session discussion may be disclosed to the membership. I don't know any boards that actually follow all of that statutory language, to the T, but that's the language that's actually in the statute. So I recommend trying to comply with that as much as possible. Just letting owners know it's more about transparency, letting owners know why we're going into a private session, and under what circumstances later on we'll be able to divulge what we're discussing.
And Bruce, that's a perfect segue, transparency, which leads us into our next topic, which is communication. I would say the better ran communities that we represent do a very good job of distributing information and allowing sort of a two-way communication between owners and the board, or sometimes the management. Bruce and I have also dealt over the years many times with owners who abuse their ability to communicate with the board and sometimes aren't civil in the way they communicate. That's frankly probably an hour class on dealing with hostile or uncivil owners. And frankly, I'm not sure I have a solution other than people need to start being nicer. But back to communication. Over the years, I found that boards that communicate often, things are more harmonious. And one of the things that folks, when litigation starts, they always throw the argument up that the board's not transparent, that they didn't know what was going on. And if you're able to point to regular newsletters, email blasts, mailers, whatever, I think that goes a long way in showing that, yes, you're doing a good job of communicating. You're doing what you're supposed to do in terms of notification under the governing documents. And different associations have different tools. A lot of it depends on the community. For example, Ken, where Ken lives, do you still use Telegraph?
Carrier pigeon.
Carrier pigeon. But newsletters are great. Surveys, there's Survey Monkey. You've probably heard of it. It's a free survey platform, cloud-based, and we know a lot of boards who use Survey Monkey. They send out a survey just before the annual meeting, getting feedback from the owners on how they think the board did during the year, soliciting information, and it can be a very effective way to get feedback from the owners. Websites nowadays, I'd say it's pretty common for associations to have websites. What I want to talk about now for a second, and Ken, I want you to listen because I'm going to ask you. We do legal work. We do a lot of work with real estate agents, and oftentimes dealing with properties in homeowners associations. And here's something I hear from realtors frequently. We want some documents from the association, but the board won't give it to us. Or if they do, they're going to charge us $1,000. And Ken, I just want you to talk for a moment about documents and why it's important to make them easily available.
Well, the state of Oregon has statutes that the buyer, the forms are designed so that the buyer is the seller is required to provide the documents to the buyer. There's a list of documents, minutes, all sorts of things, even what percentage of the properties are past due on their payments and how many are non-owner occupied and all sorts of stuff like that. So, and sometimes the boards say, well, I'm not going to share that, but you have to. So.
Yeah, and I view it as make it easy to give potential buyers, because they're about to be members of the association. Make it easy to give documents, especially if they're already in electronic format. Send a link. But I hear this coming up a lot, that it's sometimes very difficult to get association documents. Do your part to make it easier. Websites are an easy tool to do that if you post them. Good idea usually to have them password protected. You have to register, get an account so that your reserve study and your budget aren't open to the public. And also with websites, be careful with what you're posting, whether it's available to the public or whether it's available only for members who have an account. How many of you have websites, just out of curiosity? On video, I'm looking, a lot of you hands up. I'd say it's becoming the norm. When I first started practicing this law, in 2004, the internet was still kind of the Wild West. And about 3 different times I dealt with situations where a disgruntled owner registered a slight variation, and I'll tell you this one. It was the name of the condominium. I'll just call it XYZ condominium, and then the word sucks sucks.com. And because the association didn't have a website, owners were going to xyzcondosucks.com and getting bad information because this owner was the only one that had an online presence with association information. And if you go to our website and just search websites, there's a posting that I did years ago that has some links. There's one, I think, I can't remember the name offhand, but it specializes in websites and document repositories for community associations. I think they base it on the number of lots, but it's really cheap. A lot of our association clients use it. Actually, Emma, while I'm talking, will you search that on our website? The name, I always forget it. It's kind of a cute name. All right. It'll come to me, but as soon as you say it. All right. Now we're going to move into another topic. And Bruce, I'm going to turn it over to you for a little bit.
Kevin, before you
Oh,
get
yes.
away, could you cover the items that can be publicly available to the public and things that should be not available to people that are not members?
There's no laws governing that, and most governing documents don't have anything governing that. I'd say as a general rule, your financial stuff and your reserve should be password protected. I don't see much of an issue with having your governing documents available to anyone. Bruce, what do you think? What documents should be password protected versus available to anyone who lands on the site?
Yeah, I mean, legally, I don't know that there's many requirements. And most associations, I think, would not publish their budget or any of their financial documents to non-members. But I would think rules and regulations and governing documents you can make public, particularly as you know, if you have potential purchasers who are looking to buy into the community, it's good to let them know what the rules are.
Well, how about
Obviously,
minutes? How about like a year's worth of minutes?
Most of the time minutes, I mean, I don't know that there's any risk in making those public per se. Most of the associations that I know would make those sort of behind a password protected part. You know, I don't know that there's a risk in, there's a question here, what's the risk of publishing the budget? I'm not sure that there's a risk. I think generally boards feel like financial matters ought to be sort of among, you know, for the members and among the members. I'm not sure that I know of any risk of making that budget public per se. I don't, Kevin,
Unless you're severely underfunded or have budget issues. I'm going to post this link that has the website links. Emma, I found it. Sorry, I wasn't very. Weebly. No, hang on. It was Go Gladly. That's what it was. And it looks like they even have a free website. Someone else posted, yeah, what's the risk of publishing the budget? If it's problematic, I think I wouldn't, if you've got budget or reserve issues. But yeah. And Alyssa, I recognize you. You've been in some of my real estate classes, right?
Yes, I have quite a few.
So you're a realtor and on your HOA board?
Oh, God, yes.
I'm sorry.
And I'm a landlord.
And a lot of hats.
Yes. So like the HOAs that I belong to, we do have a realtor page for prospective buyers, and everything that is on the ORF form is on there. So everybody that has any interest in buying in the community can go to that page themselves and review everything. And that's before they even put an offer in.
That's nice. I like that approach, to be honest.
It's less work for everybody.
Yeah.
It's just more work for the webmaster.
Agreed. Tam Herndon, I just saw, are you drinking wine right now? Oh, I can't hear you. But I guess that's another benefit of Zooms, I guess, is you all can enjoy a
Yes,
glass
I
of
am
wine.
I
You
am
are.
drinking wine and I didn't know that you could see me.
Hey, I'm always paying attention. Now, Pam, another question. Are my jokes getting more funny as we go?
That's actually just my second sip, so.
Okay. All right.
I do enjoy you.
Good. Now let's talk about risk management. This is one of Bruce's favorite topics. Right, Bruce?
yeah, sure.
You seem to love this idea of negligence and things that board members can do to get themselves sued. So I'm going to kind of give it over to you for, based on cases we have and the case law, what are the big areas where board members are getting sued?
Well, I think the biggest thing is that, to be aware of is that, associations are liable for their torts. And so, that applies to things like negligence, and particularly when it comes to negligence in the common property. So maintaining the common property in a way that is safe for the members to use is very important. That's a circumstance where there can be a lot of liability if associations fail to do that. I mean, obviously there's the very famous story of the condo in Florida as a kind of an extreme example, but there have been cases where there was one case, I believe, in Arizona where the association had a swing set and simply didn't maintain it for a long time. And a child used the swing set and it broke and child was severely injured, and the association ended up having I think it was a $7 million judgment against it. And of course, most associations don't have insurance liability policies in that amount. And so if there is excess, a judgment against the association in excess of your liability policy, the excess becomes an assessment against all of the lots. So I think that maintenance of common property is that maybe the most important thing. Fair housing violations are like the third rail of HOA law. Generally speaking, try to stay away from it. It's a very complicated area of law. The Fair Housing Act requires associations to make reasonable accommodations on account of disability. And so what that means essentially is that there may be an obligation under certain circumstances to provide an exception to your CC&Rs, an exception to your rules to a disabled resident. And the circumstances under which that's required can be very complicated and a lot of gray area. So if you get a request for a reasonable accommodation under the Fair Housing Act, definitely speak to your attorney. Unequal enforcement is one that owners like to throw around a lot, but the law actually has there's a lot of give there. I mean, generally you have a duty to treat owners fairly, and boards can run into trouble when they violate that. But on the other hand, most of the time, acquiescence in one circumstance is not necessarily going to require acquiescence in another circumstance. And so, I don't see as much liability for unequal enforcement as people like to throw around. And collection of assessments as well. I mean, that's essentially one of the primary duties of the board, I think, is to make sure you're collecting assessments. Everyone needs to pay their fair share. There's really more liability for your attorney as a fair debt collector than for the association itself in terms of the steps you have to take when you're collecting assessments.
Yeah.
Hey, can I ask a question about the reasonable
Sure.
accommodation?
Sure.
So a condo isn't considered a public area. And so usually when someone requests a reasonable accommodation, you grant it, but they have to pay for it, correct?
Let's
So
back up a second. Oh, go ahead,
Yeah.
Bruce.
So you're talking there about Americans with Disabilities Act, which will apply to places of public accommodation, and doesn't usually apply to a condominium because it's not a place of public accommodation. Now, under the Fair Housing Act, there is a requirement to allow for a reasonable modification of the property on account of disability. But yes, in that case, you may be required to allow an owner to make a modification to the property at their own expense.
And one other thing, generally most fair housing reasonable accommodation requests relate to a disability, but it can also relate to things involving protected classes. For example, let's say I'm a member of the Jewish faith, and it's common in that faith to mount a small metal emblem on the exterior door jamb, which in a condo is part of the common elements. And generally the documents say no owner can put anything on the common elements without permission of the board. Well, there's case all over the place. It says Even if your documents say that, the board must grant a reasonable accommodation and allow that owner to place that religious emblem on the exterior of their door jamb. And so there's issues like that as well. And Bruce is absolutely right. If you have anything that even feels like it could be a fair housing issue or a reasonable accommodation request, talk to your lawyer, because a couple of things. One, intent doesn't matter under the Fair Housing Act. If what you did or what you said has the effect of discrimination, there's liability. There's a case I read a few years ago in Florida where board of directors one day in a board meeting decides to adopt adult-only swim hours. Well, the next week, a family with children filed a lawsuit alleging discrimination under the Fair Housing Act based on familial status, and they won. Now, do I think the board was intending to discriminate? Probably not. I don't know, but probably not. Now, had the board simply adopted lap swim only, probably wouldn't have been a case. And so it's important for board members to know the protected classes under the Fair Housing Act. There's also a right to punitive damages. And the last case I read involving punitive damages, I think it was in Illinois. And an owner in a condo, she was hearing impaired. So she emails the board and says, board, I would like to have an interpreter at the monthly board meeting so that I can know what's going on. And she even offered to pay for the interpreter, and the board refused it. What does she do? She sues, she gets actual damages plus punitive damages in the ballpark of $300,000 because the board of directors violated the Federal Fair Housing Act. So there's a tremendous amount of liability under there.
Yeah,
Which
the other
leads
thing-
us, go ahead.
The other thing that's pretty tricky about fair housing laws is harassment. Harassment on account of a protected class is obviously prohibited against the association of the board. But what HUD has issued some rulings based on this idea of what they call third-party discrimination. And there are some rulings that say that in the event that there may be one owner or some owners harassing other owners on account of a protected class, there may be under some circumstances an obligation for the association to do something about it, or else the association could be liable under a theory of third-party discrimination.
Yeah.
That's pretty tricky.
Yeah.
So whenever you have somebody using the word harassment, if an owner complains to the board and says, I'm being harassed, talk to your lawyer.
Can I ask you a question?
Yeah.
I have one. We're in a homeowners association and we have a percentage of rentals in the community. And I'm wondering if we were talking about voting to have grandfather the current owners, but once they sell, to require that to go owner occupied.
Yeah.
And I'm not sure if there's laws addressing that.
There's not laws necessarily, but usually it's a PR issue. Can you get enough owners to vote in favor of amending the CC&Rs to restrict rentals? And generally, the only way you do that is if you grandfather in existing owners. But yeah, that's something you can absolutely do.
Okay, thank you.
Now, when it comes to liability, the first fundamental, most important thing is adequate insurance. And for associations, there's generally going to be a few different types of policies that you're going to have: liability, property, D&O or directors and officers, and then more and more common is fidelity. And I'll talk about each one of those. Actually, I'll ask a question. Here's a hypothetical. Guest at a condominium coming over for dinner. The sidewalks are icy. There's a slip and fall. Which policy out of these four policies would be triggered?
Liability.
Yes, good. Okay, whoever said that next, was that you, Paul?
Yes, it was.
Good work. Okay, here's one. Homeowners Association has a clubhouse with a swimming pool and it catches fire and burns down. Which policy?
Property.
Property. Oh, you folks are sharp. Okay, last one. Actually, two more. Board votes to levy a special assessment, but they don't have the authority to do it under their governing documents, so an owner sues.
Directors.
Directors and officers.
Good. Last but not least, treasurer of the association for the last 5 years has used a debit card tied to the association's account for gas and other personal expenses.
Fidelity.
Fidelity, yeah. Now, some documents might call Fidelity, sometimes you'll see it called a Fidelity bond, but Fidelity insurance is theft of money. And it's really cheap. And here's what I tell every client that I've ever met: buy as much insurance as you can afford. And it makes sense to talk with an insurance broker or agent that specializes in policies for HOAs. Several times I've dealt with certain types of communities, townhomes where the owner owns it, but there's a maintenance obligation and the bylaws or the CCNRs actually require the association to insure, and now you have duplicate insurance. Talk to someone that knows HOA and condo insurance for your association policies.
Hey, Kevin,
Mhm.
if, doesn't that fidelity also tie in with fiduciary responsibility? Because you're actually dealing with other people's money.
Money,
On
yes, definitely. Yeah, and most of the time, Fidelity Insurance will also, if you're managed and the manager ends up stealing, usually it will cover that as well, but that's theft. And then on Fidelity, how much coverage should you have? Well, whatever amount of money you have in your bank accounts at a minimum. Now, Bruce, let's kind of wrap up and then we'll go into Q&A with, some of the things that folks, board members should do on an annual, review your insurance coverage annually. If you did a major upgrade and now the value of the clubhouse is double, you need to increase your coverage under your property policy. There's also a rise in what are called nuclear judgments. Bruce, do you want to talk about that for a second and the importance of umbrella if you can afford it?
Yeah, I mean, that's just going back to what I was talking about with the maintenance of the common area. And nuclear judgment is just a kind of an industry term for very large judgments. And I think the presenter we were listening to in California a couple years ago defined them as judgments in excess of either $1 million or $5 million. But he was presenting some compelling evidence that statistically the number of those judgments is growing exponentially. And so the risk to associations is increasing. And so I think it's very important to look at the type of common property that you have, the sorts of injuries that might be reasonably expected to occur on that kind of common property. So if you have a swimming pool, if you have an exercise center, just make sure that you have a liability policy that covers the sorts of injuries, the amount of money that might be claimed as damages for the sorts of injuries that might occur. So if, in a swimming pool, obviously, it's you hope that everyone's going to be safe, but it's possible that there's a drowning, and you want to make sure the association is going to have a very large liability policy in the worst case that happens.
Yeah. All right, I'm going to do rapid fire questions in the chat, and then when we're through that, if we still have time, we'll just do live Q&A. So Bruce, this one's for you. If directors ignore an encroachment on common property, is that a breach of fiduciary duty?
Maybe. I think certainly directors, one of their primary duties is to maintain the common property. And so if you simply ignore an encroachment and do nothing about it, are you essentially, potentially, subjecting the association to, an adverse possession claim down the road? Breach of duties is always a very factually intensive inquiry. And so I wouldn't necessarily say as a matter of law, it's absolutely always a breach of duty, but there's.
But would you agree
the
board should do something to avoid a potential adverse possession claim, regardless of whether it's a fiduciary duty?
Yeah.
The next one, can owners give proxies? Yes, for annual owner meetings, yes, any owner can give proxies. That said, I have seen, 5-10 bylaws over the years that prohibit proxies. That's unusual, but yes, in general, owners can give proxies for owner meetings. What if an agenda item provides for member comments at a regular meeting of the board? Great, yes, put it on the agenda, ideally after the meeting. You could, I suppose, do it before the meeting. But yeah, I would put open forum for the owners on the agenda. Bruce, this one's for you. May the board reach a consensus rather than vote during executive session. And I think the question is, can you agree how you're going to vote before you vote?
Yeah, in executive session, I think, probably you can. I mean, to some degree, the idea of open meetings is that you're supposed to witness the deliberation prior to the vote. But if you're talking about executive session, obviously the point of that is to avoid owners observing the deliberation. So I think you could, for example, poll the directors in an executive session and then go out into an open meeting and actually conduct the vote.
Good. Next one is a little more clarity about owners making a motion at annual meeting. So under Robert's rules, a motion has to be seconded in order to go any further into discussion or deliberation. And Robert's rules, the commentary for it says, the whole point of a second is at least one other person in the assembly wants to talk about it. And the requirement for a second in a large meeting, if owners want to make repetitive motions in an effort to harass, at some point, they're not going to get seconds and the motion immediately dies. So what I said in small board meetings under Robert's rules, the formality of requiring a second is not required. You can still do it. It doesn't hurt, but it's not fatal to the decision if it wasn't seconded. Bruce, this one, you said going into an executive session to talk with a lawyer if needed is to protect attorney.
I actually wrote an answer to that one in
Oh,
there.
you did? Oh, yes,
Yeah,
you
so-
did. Okay. In Oregon, most condo real estate contracts specify documents to provide, they charge excess. Yeah, I get you are entitled in Oregon and Washington to charge a reasonable administrative fee to provide association records. The key is reasonable. Let's see, I think.
So last question, do you need a vote to not allow Airbnbs? And the answer to that is yes. If there's any restriction on renting, leasing your property, whether it be, a portion of the property, like, renting out a room, or the duration of a tenancy, that's all going to have to be in the CC&Rs. That's usually not going to be something that the association, the board, has the authority to regulate, unless the sort of only exception to that would be if the CC&Rs contained some specific authority. So, for example, if the CC&R said owners may rent their properties subject to rules adopted by the board of directors, then in that case, the board would have some authority to put those rules in place. But absent some very specific language like that, it's going to have to be voted on by the owners.
Well, how about that for timing? It's 7 o'clock on the dot.